Today, more than ever, HR professionals need to stay in the know to remain compliance and culture savvy. This podcast is about creating space for HR professionals to make sense of that delicate intersection and take away something valuable that helps you, your organization, and of course, your people. We'll unpack state and federal legislation, agency activities, court decisions, and so much more impacting the HR community right now. Here comes a disclaimer. Go ahead and read that. These days, you've got to be careful. Okay, that's good. You're getting it in. Now, let's get this conversation going. I'm your host, Tracy Justice, with co-hosts Rachel Gwynn and Chris Schrader. Who's your HR? Let's go. All right. Welcome, everybody. We're going to go ahead and get started. Now, typically when we join the studio, we start having our conversations in the background. And then sometimes it's like, oh, we have to stop to get things started. So I'm going to say hi to Rachel, hi to Chris. How are you guys doing? But I know that, Chris is going to be leaving a little bit early today. So we're going to start the conversation. And I wanted to start the conversation with breaking news first, because I know that we have on the agenda, we're going to talk about 2 court cases and understand what happened there and how we can apply some of those lessons in our workplace. But Rachel, you shared something that was like breaking news for us about IBM and what happened there, and really reiterating, what's happening and how we need to start moving, because if not, we're going to get caught. Rachel, please share. Yes.
Absolutely. So on April the 10th, IBM engaged in a settlement agreement with the federal government. And the settlement agreement was the result of an investigation by the federal government under the guise of violations of what's called the False Claims Act. The False Claims Act is an act that controls government contracts and federal dollars, and I shouldn't say it controls it. It comes in and addresses violations when people receive those funds and misuse them. So it allows for civil and criminal penalties. And in this case, IBM had continued their DEI efforts after the executive orders of this administration, and allegedly after the Ames decision, which we've talked about at length here, which is that decision from the Supreme Court of the United States that came in and said, we understand that the courts have historically, in recent history, held that there is reverse race and reverse gender discrimination. We're used to recognizing a minority and a majority, the majority being men, in particular white men, or, Caucasian white people, and the minorities being either women or people of color. And that is no longer the case, because when you read Title VII in its true context, it essentially says everyone should be treated equally, right? Regardless of race, gender, religion, all of the things. So when that decision came down, it really gave the federal government the power to come in and bring behind them the power of this decision, the Supreme Court, and say, we got you. So if you weren't listening to us before, and we really didn't have the strength to do anything, because all we had were these executive orders at the state and federal level, some guidance from the EEOC, didn't have the support from the courts at the time. And they knew, I think they understood that if they challenged it too much, there wasn't going to be any support there for them. But through the Ames decision, they got that support they were looking for. And so in their quest to hold people, companies accountable for not following the executive orders and the Ames decision, they found IBM, and they found that IBM, again, was continuing these processes and procedures in really all aspects of employment. And I'll read down here. It says that the United States alleged that IBM took race, color, national origin, or sex into account when making employment decisions, including by using a diversity modifier that tied bonus compensation to achieving demographic targets. And they altered interview criteria based on race or sex through the use of diverse interview slates and other employment practices in connection with identifying diverse candidates for hiring, transfer, or promotion. IBM developed race and sex demographic goals for business units and took race and sex into account when making employment decisions to achieve progress towards those demographic goals. Finally, the United States alleged that IBM offered certain training, partnerships, mentoring, leadership development programs, and educational opportunities only to certain employees with eligibility, participation, access, or admission limited on the basis of race or sex. So they clearly had very enhanced DEI programs, and at the same time, they're receiving federal funds. They're using those federal funds, to pay for some of the costs that these programs relied on. So as a result, they were in violation of these laws, and it allowed and enabled the government to come in and use the False Claims Act to scare them pretty seriously. And because, again, not only do we have civil penalties, we have criminal penalties. And so as a result of that, IBM ultimately settled this case for just over $17 million, $17,077,043.
17 or 70? 17. Okay, that's still a lot, though. Yeah, it's still a lot, but
it's still a lot.
Yeah.
And maybe to IBM it's not. I mean, this is a multi-billion-dollar company, but it's a lot of money to me, and I'm assuming most people that are listening to this. And of that amount, just over $8 million was restitution. And of note, and the reason restitution is an important term is because that's related to criminal charges. So the government basically said, we'll let you off the hook. We're not going to charge you criminally or go after you anymore civilly, but this is kind of what we want. And all of this money is going to the federal government. It's not going to individuals. And of note, I don't know that any individuals actually complained about this. It's difficult to tell how this came onto the government's radar at this point, but they're certainly looking for opportunities for things like this, and they found one. So that was just 5 days ago. In the settlement agreement, it does indicate that any potential criminal charges will not be pursued. So they definitely, seeking that relief was important to them in this agreement. And so this is the culmination of, we're in April now. We're over a year into this administration, and they finally have the backing from the courts that they've been looking for, and they are looking for opportunities to take advantage of that. And so I don't know if this is a warning shot that's being fired, at other companies, but I am confident that we will be seeing similar agreements like this popping up left and right for organizations who continue to defy their orders. And I do believe that that's the mentality behind this, because it did start with those executive orders. And I really think, we talk about, and I think, Chris, before we got started, we're talking a little bit about how we got here, where we are, the precipice, and all of that, and what can change, because this was a huge change for us and for our clients, for my HR clients. Again, we've talked about the paradigm shift. This is a huge paradigm shift. We used to tell you have to do this, and now we're telling you if you do it, it's a crime, right? So that's a big deal. That's
a big change.
That's a material change.
Yeah, and so let's say, in the next election cycle, we end up with a Democrat president, and they don't have any desire to follow through with similar actions. It doesn't mean it's going to go away. The only thing that can change this, again, would be the Supreme Court or Congress, an act of Congress.
True.
And so as long as that Ames decision stands, the government doesn't necessarily have to pursue these claims, but individuals can pursue claims through the False Claims Act. It's called a key tam action. And
Correct.
so as long as, so if we end up with a more liberal president who says, I'm not pursuing anything under the False Claims Act, I actually love DEI and we want to re-implement these, if individuals, maybe an employee at IBM says you're violating these what these funds are intended for because you're breaching this law, they can bring their own claim under this False Claims Act. And frankly, as the law is currently written and being interpreted, they'll have to be held accountable for that. So this is how it's going to be for the foreseeable future, from what I can tell. Now, again, if Congress flips, administration flips, they do have the authority to impact change through Supreme Court appointees or modifications to Title VII, the language in it. But until something like that happens, this is where we are. And where we're going to be.
Yeah. I would agree, and you're right. Supreme Court could change its mind. A different court could interpret differently. And Congress absolutely has the mechanisms at its in its arsenal to change those things. They do. Now, having the votes to do it and everything like that is a different thing. We've all seen, and we've talked about it a lot on this. The whole system was designed to be difficult, right? They separated powers all over the place, and ensuring that those with the separated powers would guard them jealously, as they have over the nearly 250 years of the Republic. And it's just tough to come by votes to change a lot of things seriously. And we were a long time, getting to this point. I'm old enough to remember when all the diversity stuff started. I mean, affirmative action was like the precursor experience, if you will, for employers, right? As a component of federal contracts. But it was the original understanding in HR was Title VII as just a plain reading, which is exactly what the court said. Hey, it's just a plain reading of it. And when the diversity stuff first came in, I remember thinking, holy cow, this is running actually opposite of what Title VII says. I mean, how can you really do this piece? And then it just kept on going. But from the very beginning, I remember when it all started, I thought, I don't see how this circle squares, right, without a change to Title VII. And so here we are, coming around nearly full circle, which just proves I'm old, right?
Well, no, but I have a question with that, Chris. So when Title VII came out, there wasn't and I always get this mixed up, the McDonnell Douglas framework. McDonnell Douglas framework. Okay, so that wasn't
there were a whole series of cases after that. Yeah, but anyway, go ahead.
That wasn't a thing yet. It was just a plain reading of Title VII. That's what it was intended until a court case was tried, and then because of that framework, that's what changed DEI to be,
I don't, and Rachel, you'll have to keep me honest on this. I don't recall a particular Supreme Court case or even an appellate level decision that codified diversity.
With that perspective,
within the concept of Title VII.
Of the majority, the unusual. What is it? The employers being unusual with their hiring practice, and they're discriminating against the majority. I wonder, when did that become a thing on top of Title VII that kind of skewed the way we look at that?
I think your question, Tracy, and correct me if I've interpreted it wrong. I think where you're going with this is. Are you talking about when did we get into the concept of protected classes within Title VII? Is that your question? Because that was definitely a case. But is that your question?
And then let me add to it just to make sure that I'm clarifying that there's a plain reading, but then for some reason there's another layer that was added on top of the way that we understand title. And so in the past, cases were being tried against that new framework as opposed to the plain reading.
Yeah,
and I'm just like,
you're talking about how protected classes got established.
Okay.
So now I'll kick it back to Rachel.
Okay, because it looks like Rachel's ready too.
Yeah. Okay. So I think we have to think about why Title VII exists, right?
Okay.
So it is the Civil Rights Act of 1964. And I think everybody on this call knows what was happening during that time in our nation. And so the intent of this statute was to protect, I believe, the underprivileged in this country. And it was those protesters, those civil rights advocates that brought this statute to life. And so while it was written to, I think the ultimate goal was for equality, there was a lot of equity considered when this went into place. And I have always told my clients, we are all members of a protected class because everyone fits within a race, everyone fits within a gender, right? And so it has never said, if you're white, you're not a member of a protected class. If you're a man, you're not. It's never excluded. But how it was understood and interpreted from the beginning was that if you were of a minority status, it was more likely that you were to be discriminated against, which frankly is a factual statement, right? Particularly during that time. And so because of that, over time and in the case law, what we saw was what we referred to until recently as reverse race or reverse gender type discrimination, because it was possible to be discriminated against as a man or as a Caucasian, but the legal standard was more heightened to prove it. So that's where, like in the Seventh Circuit, they would say there's something fishy going on, and we've talked about that before. Other circuits had different phrasing that they used, but it had to be a little more than for someone of a minority status, because it was harder to believe that someone of a majority would be singled out and discriminated against under normal circumstances. However, if you had an all Hispanic restaurant or all Asian or any kind of business, frankly, you're a Caucasian trying to get in, but maybe you don't speak the language and everyone there speaks the language, that might be enough to say, hey, it is a unique circumstance because I am, although maybe in the greater population of this country, I may be the majority, but in my work situation, I'm actually a minority. I'm being singled out. I'm being paid less. I'm being whatever. And that could be enough to get you through that. But under normal circumstances in a normal work environment, the standard was higher. And what Ames did was pulled that heightened standard back and said Title VII never contemplated a heightened legal standard for any race or gender. And they're not wrong. The statute never explicitly contemplates that. Did the legislature, when it was originally enacted? Probably. I think probably because that's why it was enacted to begin with. It wasn't to protect white people. It wasn't to protect men. In male-dominated industries, it was to protect women. And we've seen additional legislation come through, like the Lilly Ledbetter Act, the Equal Pay Act, and other things that since Title VII was enacted, and they have continued, those legislative actions have been focused on underprivileged people, age discrimination, disability discrimination, all of that. So, but again, it's hard to disagree with Ames, the court in Ames, because
it is.
The plain reading of the statute is everybody should be treated equal. And so, so that's, I think, kind of where we started with it. But now, especially with the court having the support of the administration and Congress, I think it was a very easy decision for them, for the circumstances. Had, this been challenged in the early 70s and
different, okay.
I think we would have had a much different outcome. But that's, my 2 cents.
And that makes sense because we're in not to say that all of these issues have gone away, but there's still different ways that we can go about it. We're not necessarily stuck. Maybe back then certain people might have been stuck and this was their only way to feel like they're living a good quality of life. But I don't know, were you going to say like maybe not so, right, in
Yeah, the two
2026?
cases that you're going to talk about,
Mm-hmm.
that's not the case, right? So we're not
Exactly.
the two cases that Tracy brought up. One is, I believe, focused on disability, and one disability is race,
Yes.
and the
This.
other is gender. Am I wrong? Was it gender
Well,
or
the other one was
Age.
more ageism. Yes,
age?
which
Yeah,
which is interesting too.
yeah.
Um,
So we're not, but we have seen, and in Ames, it was, I think it was a straight person, right? Who felt they were being
We
when you
lost.
move, Rachel, when you move your headphone, you kind of
Yeah.
can like. So I wonder if. Okay. Okay.
Can you hear me
Talk
now?
again.
Yeah.
Okay.
Okay. Yes.
Sorry.
Yes.
You
Okay.
accidentally shifted your mic down.
Okay.
Yeah.
Okay.
So as long as
Okay.
you
Yeah.
keep it up, you're good.
Yeah. So,
No.
but
Very
Ames
good.
was that a great example of what we would have considered reverse discrimination, right? The facts in Ames is the point I was making. So it does exist. It's just easier now for someone that's Caucasian or a male or straight, being discriminated because
Because of
maybe
the
they want
aims, it was
right.
more of that.
So
Yeah. Straight
yeah.
versus yes.
So we
Yes.
don't have the heightened burden. It's easier for people to do that. But I think again, the cases that you brought up earlier and plan on talking about show that the reverse of that still exists too. So,
Mhm.
So yeah, so what I'll do is I'll share the high overview and then see what you all have, what came up for you and when you started researching, because I feel like I went down a rabbit hole of like really trying to figure out a lot of stuff. But the overview is the case involves a disabled. So we're looking at sample the I'm going to say Chemex construction material specific. If I said it wrong, somebody can correct me. But this case involves a disabled African American employee who alleges he experienced ongoing racial and disability based harassment. And I say alleged because just I'm not sure if they can go on any further after this. If there's another level for the employer to for this case. But it was due to racial and disability based harassment, discrimination, and retaliation during his employment. The employer argues that the employee's termination was lawful due to misconduct discovered after the fact. So he alleges he was exposed to repeated racial slurs, disability based insults. He had an issue with his ear, and it when you looked at it, you could see that there was something up with he had a congenital disease, and because of that, he was receiving slurs. They were calling him names. There was noose drawing. I mean, this case just seemed like it had everything that we talk about in HR, and it's just like, where was their HR in this situation? But they were being sued too as well. So 3 of the HR staff members were being sued as well as a plant manager. He said he complained through union grievances. He spoke with the management, and the employer claims it was not properly notified of harassment. And then they also claimed that the employee failed to use formal reporting channels. Now, of course, we know what happened here. What came up for you when you guys were doing the research on this and looking a little bit deeper from your lens?
Well, the first thing that jumped out to me is that he was a member of a union.
Okay.
And so these would have been almost certainly other union members who were engaged in this, right? And because the thing that was puzzling to me, because he argued about that, and the company says, hey, he didn't follow processes. In any union, in any labor agreement, the grievance, the whole process, the grievance process, anything that you would follow to make a complaint as an employee is very detailed and specific, and leaves no room for guesswork, right? And I personally, having worked at GM, I know the union hates being put in these binds when it's kind of like member on member.
Oh, okay.
But they don't want to drag management into it. They want it to stop, but they just really struggle with these kinds of things, and so they try to tamp it down. They try to use leverage, and stuff like that as best they can. But my guess is here, the union itself probably played a role in not surfacing it to management because it was its own members who would be clipped, right, for their behavior and their conduct. So I think that kind of mucked this up. That's why the minute I saw this going on, I was like, in a private sector where no union's in the way, probably HR is on this like white on rice, and management is too. But now you got a labor agreement in there. It's a represented workforce. I think that unfortunately clouded it relative to this particular complaint, because I'm not gainsaying, and I have no direct knowledge, obviously, that everything happened the way that the complainant says it happened. But I similarly find it hard to believe that nothing happened, right? That there's no way that went. But that fact to me, the whole arrangement, having personally worked in an organized arrangement, I could see how the union struggled with this one.
That's an interesting perspective. Going through my rabbit hole, that was not a perspective that I thought of, and I can definitely see that. What do you have to say, Rachel?
So, I mean, that's definitely a possibility. I've been involved in plenty of labor situations where, if you, as the employer, if you discipline an employee for some of this behavior, you may now have a grievance situation on your hands. You could potentially be going to arbitration. But I don't think that alleviates the employer's responsibility to deal with it. The additional hurdles that you may face, don't take away your accountability.
Mm-hmm.
And clearly the jury in this case did not find that compelling if that was an argument. I will say that the court on motion for summary judgment dismissed all of the individual claimants. So he did have those claims. And I think what I took away from that is, because he brought the claims through Title VII, some of them. In Title VII, you cannot sue individuals. It does not give you that ability. But at 42 U.S.C. Section 1981, for race discrimination and engaging in contracts, that law does. And so this was a California case. I'm not licensed in California, but it did talk about California's Fair Employment and Housing Act. So that act must also allow for a claimant or a plaintiff to get to individuals. And so
that'd be my guess. Yeah.
Yeah.
Oh,
so
okay.
He lost on that at summary judgment. At the end of the day, that doesn't matter a whole lot. What it matters for is your ability to get like punitive damages against individuals, and you can escape the caps that Title VII provides, right? And so this $5 million award far exceeds anything that Title VII would typically allow, even for a large employer. And so again, I go to this fair employment law, which must be what has opened that door for him, allowing for him to get these additional damages. And I also, I don't know that it's a takeaway for me, but it's, I think, something important for our whomever is listening, the HR representatives, to understand that, it's never, the courts never expect us to know everything that's going on everywhere within our organizations. And we are not automatically responsible for what one employee does to another employee in this discrimination realm. But we are responsible once we know about it.
Correct.
And so whether who he told or how he told his story, the jury believed that this HR department knew enough that they should have intervened, and they didn't. And by intervening, it's your responsibility to make sure it doesn't happen again. And if it does happen again, it's your responsibility to deal with it and really make sure it doesn't happen again, right? All of these tests that are in these cases are, what kind of an investigation did you conduct? How hard did you try? You don't have to be perfect. You do not, but you've got to put your best foot forward. And you've got to do everything within your power to protect this employee who who's being singled out, who's being harassed, who's being mistreated, and the jury did not believe that that happened in this case,
Yeah.
and so that's why they instituted this award. And to your comment earlier, is there anything else the employer can do? There is. This was a decision at a district court level. They can appeal this to the Ninth Circuit, and they might. That's not in the articles that I read. It wasn't indicated that they said they didn't agree with it.
That's what I read too. But
yeah, I haven't. This was is this last? Wait, how old is this case? I'm trying to see. It doesn't say.
I think this is two. I think this is two. I think this is 2 years or close to that.
23.
This is Cemex. CEMEX, is that what this is?
Yes, CEMEX,
Yeah,
yes.
this is Cemex, okay. Because as we were going through that, I was like, I remember this case. Yeah.
Yeah, so if they were going to appeal, or if they did, I mean, that's not included in what I read. And so what they probably did was came to some kind of a settlement post jury award, and that's very common.
Yep.
They'll say, because it would have probably been this $5 million plus attorney's fees for the other side, plus they already had to pay their lawyer, and so who knows? It's California. Who knows what those lawyers were charging?
A whole other country.
Yeah. And so it really is. And so these awards in California aren't that unique. It feels like a big deal to us, right? That's very rare. We've had some pretty big awards here recently, but in California, this isn't that crazy. California, New York, Illinois, you see the bluer the state, the more you see the juries have more compassion. And that's a science. It's not my opinion. There are tons of studies that indicate that. For example, our juries here in the Northern District of Fort Wayne have an average of 10th grade education. They are traditionally farmers by background, very conservatively religious, and they do not favor large awards. They have a you pull your bootstraps up and figure it out and move on mentality. They'll give you they will historically, if they agree with you that you were wronged, they will give you what can be quantified. What were your medical bills? How much were you out on lost wages?
What does it add up?
Yeah, they don't like emotional damages. And so they give us something finite. In California, you're more likely to get, frankly, more compassion and a bigger, where, hey, you were wrong. I have more empathy, and so I'm going to, give you a larger award. So that was kind of my take on this case. And had this same case been tried in Fort Wayne, Indiana, it may have had a very different outcome. I mean, we about a year and a half ago had a trial here. It wasn't an employment case; it was a civil rights case where a gentleman was. I was not involved in this at all, so this is just knowledge of what happened to the courthouse. He was arrested. He was in the jail and handcuffed behind his back, sitting, waiting for him to be booked in, mouthing off to an officer. This is all on camera. The officer punched him in the face or the head. The officer was charged and convicted of a crime, a battery. The individual then sued in our federal courts here in the Northern District of Indiana, had a trial, and the jury ruled against him. So in spite of the fact that this officer was criminally charged and convicted, this individual lost in a civil trial because the jury is very pro law enforcement. There's a kind of hey, if you're in jail, you've done something wrong, and you probably shouldn't have been mouthing off to that officer. So
no, I know I'm smiling, but but I think it's fair to be able to interpret, the different landscapes that some of these cases are being tried as well.
And venue matters.
Right? It really does.
No, for sure.
Indianapolis could also be very different. It's very
and that's why I always tell people, HR pros, if you're managing in a multi-state environment, and I just hammer this into my students, you absolutely 100% have to understand that just because the laws work in your state one way and have that happen, don't forget that we are a federated republic of sovereign states. So they have their own rules, their own laws. They have to follow federal laws. They have to adhere to the Constitution. They have to do all that stuff. That was those were all conditions of being admitted into the union, right? Into the
Okay.
federation. But when you cross state lines, it means something. Right? I mean,
not even just state lines, Chris. I mean, if you're the difference between being in Indianapolis and Fort Wayne is pretty substantial.
oh yeah, absolutely.
Oh, really?
Yeah, and
Oh,
County.
really?
Yeah.
Okay, then that needs to be a session then. Okay, because
that was my reference to venue.
Yeah.
Really? I didn't realize it was that granular. I think I was thinking about state-wise, like national, like, okay, different states, but I wasn't thinking like even different cities within the same state can be
sure.
substantially different.
County, Tracy. So the Allen County jury, our Allen County courts pull from a much more diverse and frankly statistically more educated group of folks than your 10th grade farmers. And I don't mean for any of this to sound derogatory towards anyone.
No,
and I don't see it that way. Hopefully nobody sees it that way.
Clients who are the hardest working people.
Yes.
Just speaking demographics. So salt of the earth, most successful, great people. But it impacts their perspective. And how they take information in and how they feel emotionally, because these decisions are emotional. They're not fact-based. You listen to all this emotional testimony. I mean, that's a huge part of if you're a plaintiff's counsel presenting your case. Look at how terrible my client was treated, or look at how physically my client has been injured. Let me bring in these doctors to talk to you about the pain that's associated with this, or so on and so forth. And so some people are more inclined to have empathy. And so again, even in our jury pools within Allen County are much more liberal than the courthouse that is literally not even a mile away, but has a jury pool from all surrounding counties, DeKalb County, Steuben County, Noble County, and all of those. So that it pulls in the rural area. So you may have a jury trial in Fort Wayne, Indiana, but you may have one person from Allen County on your jury. And so we can almost always predict in that court what your jury is going to look like, because the population is pulling from such a large pool that very often may not include it. And if you're, an attorney's trying these cases, are smart, they're strategic, they know what they're doing. So if you're on the defense side, you're going to try to get those city folks out, right? You want those rural folks in because you know what the studies tell you about how they're going to rule at the end of the day, for better or worse. So,
Yeah, I would agree. But yeah, getting back to my point, if you're going to manage in a multi-state environment, and you're going to have a location within a state, obviously, and it matters at a granular level, as Rachel's been pointing out, you do have an obligation as a practitioner to be aware of that. Right? You always have to be aware of your operating environment, kind of no matter where you are. And I have seen, multi-state HR practice, and I've been 2 times when I was VP of HR at 2 different companies. I had employees literally in all 50 states, right? And that is a truly unique challenge in practice, right? I mean, I remember those times I went to another job, and we only had employees in 4 states, and I was so grateful.
It is a real challenge, Chris, and I think it's becoming, in order to have that experience before, you had to work for a really large corporation, right? Today, post-COVID, we have so many people working remote that so many of my clients, I just had this, where we're doing a handbook, and I'm like, well, do you have anybody in other states? And they're like, well, yeah, Florida, this, that. And I'm like, okay, let's slow down. Now we've got to take a step back because we need addendums for each one of those states. And the smaller the company, the less likely they are to understand that, because they don't have the team to support them, right? And so, but for example, Michigan,
they don't know what they don't know.
Right. Michigan has very unique leave laws that have been enacted over the last couple of years. And even if your base is, Fort Wayne, Indiana, or Indianapolis, or Bloomington, you've got to honor those Fort Wayne leave laws for that employee. And so if you don't, you've exposed yourself to liability in Michigan. And there are obviously a lot of other things, even how you allow people to store their guns. So if you have a physical, a presence of a company, whether someone can bring a gun to work varies by state to state.
Absolutely.
And how those guns can be stored. So you cannot just have a no guns rule across the board. You're violating people's rights depending on the
Interesting.
state. Yeah. So
what is it here in Indiana? And I know you got to go, Chris, but what is it here in Indiana?
In Indiana, it's just got to be locked in your glove box or your trunk, or placed somewhere. It could even be under the seat as long as the vehicle is locked.
Yeah. Yeah, I had, but before that law was passed, because Indiana passed that, I think, when Mitch Daniels was governor. I think that's when that particular law passed. Before that, we didn't really have one, per se. And I remember vividly, I worked manufacturing company I was working for at the time here in Indiana. We made our own rules, obviously, and we said that employees, if they brought firearms, they had to be secured, unloaded, and locked, inside of a truck and out of view, right, and out of view. I only had one exception: hunting season. Hunting season, because so many of the first shift workers, because your daylight's starting to go, and it was near religion with that manufacturing work.
No, it's real. It's a real thing, but it's just
I
got it.
So I had one exception. The exception was opening day of hunting season, and because the hunting season, you don't shoot deer with a handgun, right? I mean, you've got rifle or shotgun. And so I said, okay, those got to be in your gun racks. They got to be broken and open so we can see. Bolts out, if it's a 308 or something like that, bolts out all together, observable. My staff would walk the parking lot and check every single truck, make sure.
Wow.
These guys all drove trucks. I don't know how many people drove cars, but it was mostly the admin people. But we viewed all that, and I was like, you break that rule, you lose the right to do that. So that means you're losing daylight, right? Because that's what all these guys are doing. As soon as the shift is gone, they're Flintstoning out and heading out to hunt. And that was the only exception I had until Indiana changed its laws, right? But I was long gone from that company by then. I assume they comply. But Pennsylvania is a state I know for sure. That's very different rules around that, because opening a deer hunting in Pennsylvania is actually a state holiday.
I mean, that is just a really interesting, but it just shows you, being able to understand, the demographics, what's going on within your workplace, and then making rules that make sense, understanding where you're operating, but then, tailoring it to your people instead of a blanket law. So that totally makes sense. But I have a question I wanted to bring back to you, Rachel, because we were talking about the FEHA, California FEHA, and you can't personally sue. You can't sue individuals through Title VII. Only the employer can be sued through the Title VII. But what's interesting about this case is that when the $5 million that he won was compensatory and it wasn't punitive. So with that, it all came from but you said that was a large amount for it to be a Title VII award.
So it doesn't have to be against an individual to exceed that, the Title VII cap. And I'm making some assumptions based on the award and some other things that were said in here, that this California law also is consistent with 42 U.S.C. Section 1981. Because I think it talks about something. It mentions the interfering with someone's ability to contract, and the courts have recognized that an employment relationship is a contractual relationship, even though you are not technically a contracted employee.
Correct.
The relationship by itself is inherently, and that's where, because there were challenges to what I call 1981 on that issue, that 20, 30 years ago that has since been well established that relationship exists. This seems to be kind of a mirror of that, although clearly it has some extensions because it talks about housing. Although 1981 isn't limited to employment or housing, this law appears to be. For example, 1981 has been used in cases. There was a case of a retail store where could go in and try clothes on. I'm trying to think of how to not disclose anything.
Yeah.
And they had a sign up that said, for women, if you have a large bag, you have to leave it in this basket right outside the room. And an African American woman went in and they asked her to put her bag in the basket, but she had noticed a Caucasian woman go in and they did not ask her to. So she went back, same thing, filed a charge of discrimination based on a local law, but then also ultimately sued based on that 1981. And an investigation was done by the local human relations kind of EEOC subsect. And so they went in. So in that situation, it's not housing. The point I'm making is that it wasn't employment, but even shopping can create a contractual relationship, right? This is a public place. I can come in, I can buy something. That interaction between us is technically a contract. And so that law, that 1981 law, can be that broad. That it is focused on race and national origin. So all of that, I really digress there. I apologize. But this law here...
No, that was helpful, though. That was helpful.
Because that law doesn't have any caps, right? And so that's why for employers and HR professionals, that law is really dangerous. It's more dangerous.
Yes, dangerous.
I agree.
Yes.
Yeah.
Okay, because that's what doesn't have the cap.
You have no caps. You can get damages against individuals and the company. I mean, it just really opens up this whole can of worms and can really change the landscape of what was otherwise a lawsuit with a lot of limitations. And I think that's what happened here.
Yeah, and California is famous for having very high ceilings for damages on things, way other states. So I'm sorry, I got to bounce.
Well, yeah, because the next case. I know you got to go. Okay.
Yeah, but I will definitely be here for the full program in May because students will be out. So I'll see you.
Well, thank you so much, Chris, though. Appreciate that.
Bye-bye.
Yes.
All right. Bye.
Bye. And so what's really interesting, and then I'll fix the screen here.
Let me just real quick.
Let's
So on this, for example, if this had just been a Title VII case, the cap would have been $300,000 plus front pay, back pay, and attorney's fees. And so it's in front pay and back pay can be substantial, but based on this guy's job description and where he was working, I don't think there's any realistic world where he was earning the kind of wages that would have gotten him to, even with other benefits, retire. There's just that 5 million mark. Yeah.
Yes.
So,
yes.
1981. It's not. It's a federal regulation, so it can anyone can use that tool, to bring a claim, but it is limited to that race national origin issue.
Now, and that could also be within the same case that you're trying under a Title VII, and that's okay. Like here in the state of Indiana. Okay, so then that could have. Okay, so then
they have different causation standards. So I don't know what California's causation standard is. So in Title VII, it's a mixed motive. So Title VII's legal standard is easier to prove. So if I'm suing because I believe I've been discriminated against based on my race or gender, I don't have to show that it was the only reason that I was discriminated against. I just have to show that it was one of the reasons or part of the reason. Under 1981, they have what we call but-for causation, and that means but for my race, but for my gender, and frankly, gender doesn't apply to 1981, but for my race, yeah, so it's the only reason. So that's hard.
Okay.
It's harder to prove, but if you can prove it, you then get this whole kind of wide open door of whatever the jury wants to award you.
And it's really interesting. So then I think even going back to the state of Indiana, so then for Indiana, if Indiana is an employer-friendly state, and we're not necessarily saying that, I mean, I think we've already said that it wouldn't necessarily play out the same way that it played out for the state of California. But what like if titles if Indiana's more of an employer friendly state, how could an employee bring up something? Would it have to be something outside of Title VII? Would it have to be like a tort or a separate claim if you feel like you've been, treated unfairly?
To get an
What do you,
award like that, yes.
yeah.
And
Okay.
so tort claims are limited to government, right? So we refer to certain laws as tort laws, but we don't have to worry about that in this conversation. But like an actual tort claim is a claim, it's an administrative remedy that you have to do before you can sue the government, whether it's a local or state entity. You file just a note letting them know the time, the place, who was involved, and what the damage was. And so you send that. Let's say you fall, on the sidewalk or hit a pothole, and that happens a lot. And then people will send a notice to their local municipality and say this is what happened, and they outline what I just described. And then those cases have caps, and in the state of Indiana, that cap is 700. I always get 700,000, I think. And there are some things that fall outside that cap that can be in addition to it, but generally speaking, that's the limit. And then you have, for employment purposes, that 1981 is something that you can use only for race or national origin claims. But that is a law where you can again sue individuals, and you can exceed those Title VII caps. You also, the Fair Labor Standards Act allows you to sue individuals as well. A lot of HR professionals don't know that, but if you are intentionally interfering with people's wages and impacting their overtime, their minimum wage, or any of those things, you can be personally held accountable for that. And so,
Wow.
people need
for LFSA.
FLSA, yes.
So, like an FLSA audit, if a person feels like they were categorized incorrectly, like they shouldn't be exempt from overtime, and they're being exempt from overtime, like they can personally, can they hold the organization liable and the HR person, or the HR person can just, wow.
But under those claims, your damages are limited to the amount owed times 2. And there's a good faith, bad faith argument about how that plays out in attorney's fees. So typically the biggest claim in an FLSA case is the attorney's fees, which is why attorneys love to take those cases. And that's why when my clients call me, my corporate clients call me and they say, hey, we've got this issue, I'm like, oh my gosh, if you've done something wrong, let's figure it out right away and get that check issued, because we don't want to be paying their lawyers' fees plus you paying me plus paying them, because that's almost always the biggest risk.
So FLSA, I don't think maybe there's a part of me that wants to think that maybe I do, because I think I read something here in the state of Indiana, because here in the state of Indiana, you can't interfere as well, right? Like there's some kind of law. Yeah. So
you have
maybe
the overarching FLSA, which is the entire nation, right? What we were talking about earlier, kind of, there are things that the federal government controls that we all have to follow. And then each state often has its own legislation. And this is something where Indiana is really unique. Very often Indiana follows the federal rules. So like we don't have any break laws in Indiana. This is something people are often very surprised.
Which is funny. I found that out. It was like, oh, no break. I can make you work a full straight day without taking a break. Interesting. But good thing that they don't do that. But, wouldn't be a great place to work, stay, and live.
Sure. I mean, it's bad business and you have to pay overtime and all this stuff. It's bad business practice. But yeah, you can do that because people complain to me, and I'm like, there's no break laws in Indiana because there's no break laws through the federal government. And Indiana follows the Department of Labor. So we have the Indiana Department of Labor, but it is mirrored by the feds, just like we have IOSHA mirrored by the feds too. We just have our own government agency that oversees it internally, but they follow the federal rules. So, but what we do have that's unique in Indiana is our Wage Payment Act and our Wage Claims Act. So they're very similar and they require just about everything that the federal government requires, but they oversee some things that the FLSA does not. For example, wage deductions. So
yes.
if you want to take money out of your employees' checks beyond traditional taxes, insurance premiums, then you have to have what's called a wage assignment form.
Mm-hmm.
And it needs to outline exactly what's being taken out. Your client has to, or your employee must sign it, and it's revocable, right? And so oftentimes
Yes.
employers will maybe lend a client money, which you can do, or they'll lend them PTO time, and then they'll have them sign the form. But as soon as, let's say, the employee gets mad and walks off, they can say, "I revoke that form. My last paycheck. You can't take that." And then the employer's like, "Well, hold on a second, right?" And that's
Yes.
probably the most common kind of hiccup that I see, where employers will take things out of final paychecks that they should not. And now you're kind of under the same situation as the FLSA that we just talked about. Damages are limited. You cannot sue an individual, but it's a very easy case to win if the wrong is apparent, because the law is very clear on what you can and can't do, right? So
Yes.
I know we've definitely digressed into a whole nother
No, it's
area,
okay
but
because no, but it's okay because I think that when it comes to this information, I think if anything, as I was like researching and going down the rabbit hole, you realize that there's so many nuances that as HR professionals, it really is a tool. Like Chris always likes to say, it really is a tool in our HR toolkit to really understand, like interpret case law, and maybe not to become an attorney, definitely because that's just way past there for me. But I think being able to understand all these different nuances, because I didn't realize I didn't realize that they were different damages that or caps for each of the different for the different agencies or the different laws like FLSA or Title VII. I didn't realize that. But you know what? And I know we don't have that much time. But there was a question that I definitely wanted to ask real quick in the summary judgment.
yeah,
Now, when I was looking at summary judgment, I noticed that with the summary judgment, and for those that are listening, definitely research this Slagel versus Liberty Mutual. And if you have questions on that, reach out. We can definitely bring on another session to talk about that. But there was a summary judgment on that, and the summary judgment when they initially the employer sent, "There's no triable issue, just pass a summary judgment," or something like that. Just they're going to lose, just vote in our favor. I don't really know what the terminology is.
yeah,
Go ahead. What did you just say?
he appealed it, right?
Yes. Yeah. So, but I just thought it was really interesting how, and that, that's something that, an employer can do is say, there isn't a triable issue here. So we just want you to go ahead and, just decide as a judge. You don't need the jury to make a decision on this because there's nothing for the jury to decide on, and just go ahead and rule in our favor, which I just thought was an interesting thing.
Yeah,
What is that about, real quick? I mean,
yeah, no, so that's probably I don't know that we have enough time to really
okay,
delve into
okay,
it, but I will
okay.
tell you that it's a Rule 56 motion, motion for summary judgment, and because what you're doing if you're a defense attorney, if you're the employer, is you're saying to the court, "Look, we agree on all the facts," and so taking all of that all of that in the context that we've presented it in our motion, and we've done depositions at this point, we've done all our discovery, and so we're going to say we agree on all the material facts, and so taking all of those as true, we still win as a matter of law, because the law says that looking at all these facts, it's still not a violation of Title VII or the ADA or whatever it is. And then the plaintiff responds and they say, "No, no, 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 we don't agree on all the facts. What they've painted here is not what happened. And here's our evidence, and here's our depositions and our discovery." And so we absolutely disagree with there's a material issue of genuine fact or genuine issue of material fact. And we think the law says this is clearly a violation. And so then the court takes all of that into consideration. And most of the time, by a large margin, especially in Indiana, they agree with the
Uh-huh.
employer and they throw the case out. And then, or they'll agree, like in the first case we talked about, they'll agree on some points. Like in that
Mm-hmm.
case, they said these individuals don't have individual liability, but you can still go after. They don't fit the standard for that, but you can go after the company. So sometimes they'll agree in part and deny in part. And they can do that. But if they agree with the company on everything, the case goes away. But it's not done yet, right? Because just like
Yes.
in this case, the plaintiff can say, "I think you got it wrong, court, respectfully, and I'm going to
Mm-hmm.
appeal your decision to the appellate court." And then the appellate court, you have a panel of judges, at least three typically, and they will read your briefs. You're going to submit new briefs. You're going to explain why the court got it wrong, and then they can agree with you or disagree with you. Now, whomever they agree with or disagree with, the person that loses can then take it to the Supreme Court, right? That's the process 99%
Mm-hmm.
of the time of how we get to the Supreme Court. But when that appellate court rules, they'll say, and then like in this case, they said, lower court, you got it wrong. You're going to have a trial, and it's going to be
Yes.
based on our decision. And that's what happened here. And so it got kicked back. They had a trial, and the jury agreed that this person had been discriminated against and awarded a very large amount of money
A
that went over
very
100 million,
large
right?
amount.
Yeah.
Yes, 103 million. So we are at 5 o'clock, so I'm definitely going to respect the time. But thank you so much. Great conversation.
Yeah.
Love talking about case law and applying it to HR. And you're going to
Real
say,
quick, yeah. May 14th,
yes.
NYRA's annual conference in Auburn, Indiana. I know it's on my LinkedIn. I'm not sure, but come see Tracy and I. We're going to be presenting that day. Senator
Yeah.
Justin Bush is going to be presenting with us, and there will be a lot of other great presentations talking about updates in the law, how to be a great leader, how to manage your team effectively. There's so much information, so many great sponsors, and so please do join us. There's a discount. It's only $25 if you're a student, not only to join NYRA, which is the Northeast Indiana Human Resource Association, but also to attend this great conference. There's snacks, lunch is provided, opportunities to win lots of prizes, and just get all this great information. And you're also eligible for credits for whatever licensing agency you are through, whether you're a SHRM member or another member. We do provide those credits. I think we're specifically sponsored through SHRM, but I think there's opportunity for other credits as well. So,
No,
yeah,
that's
check us out.
awesome. Yeah,
Yeah.
thank you. And you said it's on your LinkedIn page? Because I definitely
Yeah.
should have got that so then I could have broadcasted it on, before
That's
we
okay.
headed out. So I'm going to go to the LinkedIn and share that and make sure that the link is on this video as well so that people see that they can go down and see the link as well. We're excited for that opportunity. Definitely creating spaces for HR professionals to grow. I mean, that's what it's all about, growing. Thank you so much, Rachel, for this awesome conversation. And for everyone else, see you next month.
Okay. Bye-bye.
All right, bye.